Today I want to introduce my friend and associate, Taylor Morris with Morris Estate Planning law firm. And the type of work that you do often comes into play when things are wrong, like go wrong, right? So maybe tell us a little bit about what you do.
Yeah, I mean, sometimes you're dealing with situations where something's happened and after the fact, someone needs to, address it. And sometimes we're dealing with clients ideally before something wrong happens, but not always something wrong. Sometimes it's dealing with things that are right and getting things in order. So, as estate planning attorneys, what we do is help people arrange for what happens if they become incapacitated or they pass away. Making sure that things are in place, making sure the right people are named to do certain things, making sure if they're alive but they can't act on their own, the right people are in place to help them. And ultimately, when they pass away, making sure they have the right people named to settle their affairs and the right people inherit what property they have. So that's kind of what we do as estate planning attorneys.
Well, thank you. I know we work with quite a few clients together, and I think you've done a great job with what you've done. Tell me, what are common misperceptions about the type of work that you do?
Yeah. People, they read a lot of things. They hear a lot of things. Sometimes they're not always accurate. But something that I think people tend to get wrong is they think that they don't need estate planning because they don't have enough money. They're not rich. They don't have anything complicated going on. And I think sometimes naturally we think, okay, I'm just a regular person working a job and doing my best, but not all of us are billionaires. But that's not what estate planning is always for. Estate planning is for everybody, no matter what walk of life you're in or what financial situation you're in. Everyone can benefit from estate planning, and that's why I enjoy it so much. I get to meet with a lot of different people. And so when people say that to me, sometimes that's why they put it off, because they feel like they're not the right fit for it. But estate planning fits everybody, no matter what their scenario is.
All right. Thank you. Well, how would you define estate planning?
Yeah, so estate planning is the legal process in which someone plans for very important events. And sometimes they are events that are scary, like if I become incapacitated or if I die. I mean, those are not inherently good or positive things, but they're inevitable. And so planning for those things is really what estate planning is for. It's getting legal documents executed and in place so that if someone goes through those types of scenarios or that happens to them or their family, it's going to be covered, and what they want will happen. What their objectives are will happen.
Thank you. What do you think, Taylor, is the biggest mistake families are making that you see with estate planning?
I think there's a couple of mistakes. One is I see a lot of people that do nothing. And I think that's the biggest mistake. It's that old saying, doing nothing is a choice, or failing to plan is planning to fail. When you don't do anything, then you're already kind of starting behind. And if something happens, it might not work out the way you want. So I meet a lot of folks who tell me, oh, we've been putting this off for years. Sometimes it's decades, and they've been married for a lot of years, and now they're 30, 40 years into the marriage, and now they're getting around to it. Luckily, they're able to still do that, but a lot of people put it off too long and they get sick or pass away, and we can't do as much because they put it off.
Sure.
Or I meet with a lot of folks that, they come in and we meet and have a good discussion, and I explain the process, and they appear to want to do it, but they don't quite take the next step to actually get it done. And so sometimes they may not actually sign the documents. Sometimes the years might go by, then they come back, but there's some missed opportunities there by just not doing it.
So the biggest mistake is not taking action, and the biggest remedy really is to do the planning, do the work, go through the process.
It's just putting one step forward, yeah.
All right. What if somebody's already did this work a long time ago? What often happens by maybe not updating their documents?
Yeah, great question. And that kind of highlights one of the other mistakes, if you want to call it. A lot of people tend to focus on getting the documents executed, which is definitely essential. You need to execute the documents for your estate planning to work. But there are some follow-up steps that people should take to really make that plan work the way it's intended to. I try and really emphasize that follow-up process because I know if those things don't happen, the plan's not going to work as the client wants. So I would refer to that as, let's use a trust for an example. When you execute a trust, a lot of times that's your focal point in your estate plan. That's the main document. That's what dictates what happens when you die with all your property and who's in charge of handling that. So executing the trust is definitely important. But sometimes people stop there. And after the fact, there's things they should do with their assets. They should put assets into that trust. And there's some things I can do directly that I do always do. There's some things that I can't do as much directly, and they have to take some steps to retitle some of their accounts. Or maybe they need to update beneficiaries of their retirement plans or their life insurance policies. I do all I can to see that through, but there are some times when clients just have to be the one to get it done, and you can talk about it to them all you want and try and coordinate, but they have to actually be the ones to do some of those things, and sometimes they don't do those things, and then years later, we find out they died or got sick, and now it's too late to do those things, and that's where the problems happen.
Sure. What are common things that get left out of the trust?
Yeah, I would say, with exception, my advice is if you can get it into the trust, then you should. So there's some narrow exceptions to that. And one exception is there's some assets that you can't put into a trust. And those are mainly retirement accounts. Mm-hmm. If you have a 401k plan or an IRA, those are individually owned accounts. Mm-hmm. So your name is going to be the owner on those accounts, and you can't really change it to your trust. So your trust is not going to own your IRA. It's not going to own your 401k. You're going to own it until you die.
Good point.
But you can name beneficiaries on those accounts, and you always should. Sometimes we might recommend having the trust be the beneficiary, so when the person dies, then it becomes part of the trust. But sometimes we might not recommend that for certain reasons. And in those cases, they need to make sure they have other beneficiaries' names, so those are paid out properly. But those would be an example of what might not go into a trust as retirement accounts. And also some things that people tend to forget about, the little things. You know, they have a timeshare they forgot about that they've had for 20 years, and maybe they don't use it as much anymore. It's not on the top of mind. They opened up some E-Trade account 15 years ago, and there's some money in there, but they don't use it all the time, so they forget about it. Sometimes those little accounts and little investments kind of cause the problems later because the attorneys don't know about them, the clients don't emphasize them, and they don't get put into the trust. And even though there may not be a lot of value there financially, it still takes work to settle those when the time comes.
What are triggers that prompt, like, hey, I should get this updated, these documents?
Yeah, I mean, life events are always going to be the most common answers to that. If someone dies, you know, kids are getting older, getting married, having their own families. Maybe the client themselves, financially speaking, you know, they're in a much different financial situation, for better or for worse. You know, a client gets divorced, gets remarried. Those are all things that naturally you think about, okay, I might need to update something. But it's never a bad idea just to, every few years, check in. You know, even if something didn't trigger it, just to make sure things are up to date. Sometimes we forget what we said years ago. Nothing may have happened, but always a good idea to review the plan and check at least every few years if it's been a while.
Great. So that's the rule of thumb, is maybe every few years or major updates.
Yeah, major life events, or every few years, just check in.
Okay. So somebody starting the process from the beginning, what's your process for estate planning?
Yeah, I like to simplify, even if it's a client that has more involved needs. It's already, for a lot of people, kind of daunting to face the reality. Okay, what happens when I die? What happens if I get sick, if I can't do things? It's not naturally a fun topic. But the estate planning process is designed to be positive. and be efficient. So I try and really bring it back to the basics. So there's going to be an initial meeting. A lot of times it's going to be in person, which is what I prefer. Sometimes people want to kind of have an introductory phone call or a video conference. We can accommodate that. So we're going to have an initial meeting. I'm going to explain the process to the client, answer their questions, learn about them, kind of what they want, and make sure that what I do is what they're looking for. And then sometimes people in that first meeting, they're ready to go. I'll get all the information I need. They have the choices in mind, and then we'll schedule a time for them to come back and get all the documents executed. Sometimes people need more time to think about the choices, gather the information. So if that's the case, we'll have a follow-up meeting to get all that stuff ironed out. But it's going to culminate with a signing meeting. They're going to come to the office. We'll review all the documents together. I'll explain them all thoroughly, make sure there's no questions, make sure they know what they're signing, making sure it's accurate. We do all the execution, the notarizing, the witnessing in the office. And then once they sign those documents, that kind of completes that first, part of the process. But then we emphasize, okay, what are our follow-up items? What do we need to put into the trust? What do we need to change beneficiaries on? And a lot of times I like to coordinate that with people like yourself who, as a financial advisor, you oversee a lot of that, making sure that you're part of the team and that you know what's happened, and you can help facilitate things on the back end by making sure all the accounts are updated and funded the right way. Right. So that kind of takes you through my process in general, between meeting them and getting the documents signed, but afterward, making sure the assets get titled the right way.
Perfect. Is it usually 2 or 3 meetings typically from start to finish? Yeah,
it's probably going to be at least 2 meetings for those who are ready to go. Mm-hmm. If they're not quite ready to go, a third meeting or at least a conversation or follow-up needs to happen in between to get the information that's needed. But ideally, that's what we're looking for, 2-3 meetings and we're done. But sometimes people do more complicated planning. It might require some more work, might be more long-term engagement. Certainly we accommodate and do that kind of work too. But for a lot of folks, 2-3 meetings is probably what you are looking at.
Wonderful. I know I've been associated with watching your family do estate planning work for over 25 years. I've always been impressed with the service and also how you explain things to clients, and they are very thorough throughout the whole process. So I want to commend you for your work there.
No, I appreciate that. And it's been a pleasure working with you as well all these years. Even before I was an attorney, you were working with my dad, and now we've worked together a lot since I've been an attorney. Yeah. But it's a pleasure to work with like-minded professionals and just kind of see what can be accomplished when you have, people that are just trying to do the best they can for their clients. So thank you.
Thank you. Taylor, what should people be asking themselves or thinking about before they come in to get work done?
Yeah, this might be one of my favorite questions because this is where I really try and focus on the basics. So again, some people they don't know what to think, or they're thinking about all these bad things that might happen to them, and it's stressful. It can be for people. So I just like to hone in. No matter if it's complicated or a more involved estate or someone that's has very basic things going on, just the questions they need to think about are pretty much the same. Question 1, if the person cannot make their own medical choices because they're incapacitated or can't communicate, who do they want to make their medical choices? Question 2, if someone is alive and they can't manage their own finances anymore, who do they want to manage their finances and take care of them, make sure their bills are paid? Question 3, when they die, who do they want to be in charge of settling their estate? Who's going to be the person or the people that make sure that their heirs get the money and that all of their, expenses and debts are covered and their taxes filed? Who's going to do all that? Next question I would say is, who do they want to receive their property? Who are their beneficiaries going to be? And then sometimes if they have like minor children, they'll want to ask, okay, if me and the other, parent die unexpectedly and our kids are not adults, who's going to raise them? Who's going to be their guardian? That's an important thing to think about too. But if you can answer those questions, you can do estate planning. There's going to be some details, some nuances, but that's what attorneys like me will help them figure out. But if you can focus on those high level questions, that can pretty much be all you need to really move forward with the process.
Wonderful. Thank you. What is probate and what does that look like here in Nevada?
Yeah. So from an estate planning attorney's point of view, like probate's the bad word, right? Probate always gets a bad reputation. I don't like to characterize probate as inherently like a negative thing. But if you want to avoid it, well, you want to avoid it if you can, and you can. So probate is a court process. And it's a court process that really only handles cases when people die and their property has to be dispersed to their heirs or their debts or expenses have to be paid. It's the settlement of their estate. So good estate planning is designed so we don't need to go through probate. But a lot of people don't do the planning. So when they die, probate's a likelihood. So probate, in my mind, is necessary because there's going to be people that die every day that don't have planning in place. And probate is the venue in which their estate is administered. But it is a court process. There's different levels to probate. There's different tiers, so to speak. And it depends on the nature of the assets and the value of the assets. That will determine what level of probate we have to do.
Is there like a threshold?
Yeah. So, I mean, the main thresholds in Nevada are $500,000. That puts you at the highest threshold. If the estate exceeds that value, then that's the highest threshold that there is. The threshold before that is $150,000. If it's between $150,000 and $500,000, it's a certain type of process. But if it's less than $150,000, then the process is more simple. So depending on where the probate falls, you might take a couple of months to go through a simpler probate process, but I'm working on probates that have been going on for years.
Oh, really?
Now, most estates don't need to go on that long, but if you're going through a probate for any regular estate with a home or with bank accounts, even if you don't have what you would consider to be a lot of property, if you have to go through a traditional probate process, you're probably looking at least 6 to 8 months to go through that after someone passes away.
Besides it, probate maybe taking time, what are some of the negatives of probate?
Yeah, I would say it's the time and it's the financial cost would be the two biggest ones. But it's also a public forum, which I don't think people think about. So sometimes people like to have their affairs be more private. There might be family dynamics where they don't want certain family members involved. But if you go to probate, anyone can go to probate court. Anyone can go to a hearing. Anyone can get a copy of the filings and see what they say. So that's sometimes a negative aspect to it. But probate tends to take longer and it tends to cost more money compared to settling your affairs if you have good estate planning done.
Great. What do you think is there a general rule about what probate would cost someone for?
It'll fluctuate depending on those levels and depending on the complexity of it. But let's just use an example of where a lot of people fall. They have a house with a mortgage, maybe a little bit of money in the bank, maybe a retirement account, and nothing complicated.
Mm-hmm.
But if we have to sell a home through probate, you're probably looking at a cost between attorney's fees and between court fees. I would say $8,000 to $10,000 would be a very standard expectation. Could be more, but you'd expect that. That's not an unreasonable expense to go through a regular probate process. Yeah.
And it seems, would it be fair to say that it's less expensive to just get the work done before that would need to happen?
It tends to be, yeah. And that's one of the advantages. I mean, you might spend some more upfront to get your estate planning in order, but it's going to save time and expense after you're gone if you don't do anything. And there's still going to be some work to do either way. Even if you have all your planning done, there's still a little bit of time and expense that's needed to settle your affairs, but it tends to be more flexible, more efficient if you can do it outside of probate than if you have to do it inside of probate.
So what are some popular things out there with estate planning that are being used with high net worth families?
Yeah, for high net worth families, that would be an example of when estate planning will take that kind of next jump. It might be a little bit more involved to address those types of issues. And really with high net worth families, the focus tends to be tax focused. They don't want to pay any more taxes than they have to pay. When you have high net worth families, it also brings in estate taxes that most of us don't need to worry about because you have to have a lot of money to owe estate taxes when you pass away. But there are very good techniques to address those issues. And in general, you'll accomplish that by some combination of gifting or selling assets from you to the next generation. So let's say it's your children. You can set up certain types of trust structures and maybe some business entities too, where you can take a lot of money or a lot of property that's worth a lot, and you can gift or sell it to different trusts or vehicles that benefit your children and their children and so on and so forth. And you can do that by, discounting what they're really worth, by leveraging it. And if you do that while you're alive and all that property over time grows and appreciates, all that growth and appreciation is grandfathered in. So when you pass away, that's all out of your estate. You're not taxed on it. And if you do it right, as your children pass away and your grandkids pass away, none of them are taxed on it either. So through using entities and trusts, you can really leverage your gifting power to avoid paying estate taxes when you pass away. But sometimes it's not always needed to be complicated. And I always emphasize charitable giving is a very practical way to plan for tax minimization. Whatever you give to charity, there's no tax on that. And so sometimes when people have a lot of money, they might get to a point where they have plenty to give to their kids or their loved ones. They have a lot of other money that they don't know what to do with. Sometimes charity is a good option because it provides a benefit for charitable purposes, but it also saves a lot of taxes too.
Great. Taylor, what about the recent tax bill last year, with new legislation? What are some things that you're thinking about or working on with clients as a reaction to that?
Yeah, I would say the biggest change that happened with the recent tax bill was it gave us clarity. It made the prior tax laws permanent. And that was what was causing a lot of unsettlement with wealthier clients. We didn't know what was going to happen. We didn't know if the current laws were going to sunset, which they were scheduled to do. We didn't know if they were going to be made permanent. We didn't know for sure if they were going to try and just do a tax reform altogether. But once the bill came out and said, no, the current tax laws are made permanent, now we know what we're working with for the foreseeable future. So now we know what our estate tax exemptions look like. We know what estate planning techniques we can use to plan for those scenarios. So that was the biggest change, if you want to call it that, is they decided to make the laws permanent, which gave us clarity on what planning you can do.
Great. Well said. So what about, you mentioned things that wouldn't be in a trust like retirement accounts. Mm-hmm. Is there anything else that you generally steer people away, from being in the trust?
I would say I don't put a lot of emphasis on vehicle titles. Those really aren't usually a substantial asset, for most people. There might be some exceptions to that, but the reason that I don't put a lot of emphasis on putting your cars into a trust, you certainly can. I don't tell people not to do it, but most people don't want to deal with the inconvenience of going to the DMV and redoing it, changing their titles, registration, insurance, things like that. But there's pretty efficient ways to transfer a vehicle when you die, even if you don't have it in a trust. If everything else is covered and all we have is a vehicle or two, then there are some forms you can fill out at the DMV to get it to the next person, and it's done. Great. So I would say that would be an exception. Sometimes clients have different dynamics going on with who they want to leave money to. And sometimes they might set up their trust to do certain things, but they might want to leave some money to somebody else and not have it be as administered or involved. So sometimes they might have like a life insurance policy or a retirement account or a bank account. They just want that to go to someone else.
Yep.
So that would be maybe an example of where they would just name a beneficiary to say who that's going to be. It won't be in the trust. It won't be divided with everything else, but that might be an appropriate example too of just trying to carve something out for someone else that may not be part of the main estate, so to speak.
Great. That's a very common question people ask, even to me on a regular basis, is what about my vehicles? So thanks for bringing that up. What about another thing that I see often is somebody, as they're aging, they end up talking about setting up a bank account and putting one of their kids on it.
Mm-hmm.
And there may be substantial assets in that bank account. What are the pros and cons of doing that?
Yeah, so the pros are that if mom or dad passes away, they're on the account. There's really no delay in accessing the money. The pro also could be that's who they want to have the money anyway. If they put it in a trust, the trust might say give it to the same person, okay? But there are some cons to that. The con is that if they make the other person a joint owner, well, now we might have a liability issue. What happens if mom or dad gets sued, or son or daughter gets sued, and they're both owners of that account? Well, that's a creditor would go after that account still, even if the other person had nothing to do with it. Because if you're a joint owner of an account and that's in your name, the creditor is going to try and go after that. So if mom or dad puts money in an account and puts their child on there, if one of them gets sued for something, it could compromise that account as a whole, even though it's really not the fault of the other person.
Sure.
The other possible negative part in doing that is they really intend for that money to go to other people too, not just that one person. But if they just stick the oldest child on there because that's who they want to be in charge, but they want the money to go to all the children, well, if it's in that child's name when mom or dad passes away, that's their money. And it's up to that child to honor those wishes. But they have no legal obligation to do it. So depending on the dynamic of the family, there might be a scenario where the child just says, you know what, I'm just going to keep that money. It's mine. Legally it is. And that's true. But it's not what mom or dad wanted. So those are some limitations.
Great.
That I would think about when clients are thinking about if they want to do that or not.
Thank you for answering that. What about asset protection? How do you define that, and what's your process for asset protection?
Yeah, we emphasize asset protection a lot. And I would break it down into two categories, if you will. One, you can own assets that are protected inherently because of what they are. And then two, you can create asset protection structures that will protect other assets too. So that first option is retirement accounts like 401ks and IRAs. Those have kind of built-in creditor protection under federal law and state law. And it might not be unlimited in both cases, but it'll protect a lot of that money. So there's not a lot you would really do with a 401k or an IRA if you have a lot of money in there. That's a safe place because the law protects it. But a lot of people have other assets, real estate, brokerage accounts, businesses, homes, bank accounts. Those are things that are not inherently protected like retirement accounts are. So for those types of assets, we would tend to create an asset protection trust. And Nevada has a specific statute that allows you to set these up. It's probably the leading jurisdiction in the country for asset protection planning is Nevada because the laws are very favorable to those who engage in the planning. And those asset protection trusts are a little bit more involved than your basic trust. And they're very powerful tools though, because over time you can put a lot of property and assets in those trusts. And if you get sued by somebody, or you face a legal situation and someone comes after you and tries to take your money, if you set those trusts up correctly and enough time goes by, they can't reach that money. So it gives you that peace of mind. And the cost and the expense to do that in the end would be worth it if something happened unexpectedly.
Great. So where do you think are the ideal candidates for asset protection trusts, or maybe, further considerations for structures?
Yeah, certainly. I would say it's going to attract clients who are subject to more risk because of their occupation.
Sure.
So if you have doctors, if they make a mistake, they might be sued by a patient or the family if something goes wrong. Attorneys like me, if we give bad advice and someone's harmed by it, they might sue me for malpractice. It could just be folks that have a lot of rental properties, a lot of tenants in and out, a lot of injury possibilities. So people that are in occupations that tend to put them at risk more, those are the ones who are going to be attracted by this option. But I also meet with clients that have a lot of money. They might be retired, or they might just have a regular occupation and they're not really worried about being sued on a day-to-day basis. But we live in Las Vegas, and it's a pretty litigious city. A lot of car accidents and hotel accidents happen, and sometimes it's just a mistake in an accident. But if you got in a bad car accident and you were at fault, your insurance might not cover all the money that the person's trying to claim. So asset protection trust can really protect against those types of situations too. Just to plan for those what ifs, to plan for those, bad situations that we hope never happen, but they might.
Perfect. What about common myths about estate planning? I think there's a lot of talk out there and misunderstandings from just my point of view. What about yours?
Yeah, I would say some myths from estate planning and asset protection too is that it has to be complicated or stressful or take a long time or cost a ton of money. I mean, attorneys charge different fees, but if you get the right attorney, you'll find that the cost to set up a good estate plan can be pretty reasonable compared to the benefits. And if you get a good attorney, they'll handle the process in a way where it's not going to cause you more stress. It's going to actually help you see that it's a positive thing. It'll actually give you peace of mind. So you don't have to worry as much about the what ifs and get so worked up about it. You can actually see the value in it, and you're going to feel better about it. For asset protection planning, a common myth I would say is people think that they can just protect their money after something bad already happened to them. They're already being sued. They already made the mistake. The accident already happened. And now they're thinking about, okay, I got to protect my money. Well, we're kind of too late there. There's not a lot of good options there. That's not where you want to be. You want to be doing this ahead of time before something bad happens. That's when the planning really holds its value. And then another myth I would say is, we kind of talked about it a little bit earlier, but it's worth mentioning again. People feel like they don't have enough to do estate planning. They're just regular folks with a regular job. Not that that's bad, but they tend to downplay it a little bit. But my point of view is estate planning fits everybody to some extent. They need it. They can benefit from it. I don't care if you're a billionaire or if you have $1,000 in the bank, you need something. So everyone can benefit from estate planning. And sometimes we don't think we can.
Good point. I mean, everyone might get incapacitated at some point. Everyone's going to die, and everyone has some risk of liability.
Sure. And then you bring up a good point too. Sometimes it's not just about the money. We tend to think about that the most. Who gets my money when I die? How do I protect my money? But if you're in a situation where you don't have a lot of money, your focus might be elsewhere. But equally as important, it might just be making sure that you're taken care of. Like you said, if you become incapacitated, who's going to communicate on your behalf? How does that work? What does that look like? How are you going to make sure your bills are paid and you're taken care of? Sometimes that's more of the emphasis. And sometimes, it may not be the size of the estate, but it's making sure the right people are there. So making sure no matter what happens to you, the right people are going to be handling things, and that gives you that peace of mind too.
Great. I've always thought in my mind, and when I talk to clients that I work with or others, is doing the estate planning process for incapacity or death. It at the very least, it reduces family friction, and which I've seen that to be the case as well. And speaking of family, one of the things I wanted to bring up too is, from your point of view, what's the value of after the estate planning work has been done, having a family meeting or having and I know that there's different names for this, but maybe having a conversation with all the players that are in the documents, the power of attorney, the alternates, the successor trustee and the alternates, and making sure that everyone knows what's going to happen.
Yeah, there can be a lot of value in that. And it's a case by case basis. Sometimes I don't think there's really a need to bring everyone together and explain things. So sometimes it's pretty straightforward. Everyone's treated equally and the same. There's no friction. But I would always at least say to a client, whoever you name in your documents, whoever your executor or trustee is going to be, or who your beneficiaries are going to be, or your kids, whoever's going to be playing a role, make sure they know how to get a hold of us. Make sure they know that you did planning at least. Here's the law firm. Here's their card, forward on my email. So they know that if something happens to mom or dad or whoever it is, they know who to talk to first. Likewise, I want to make sure I know how to get a hold of those people too. Because the person they name to be in charge, they may not know how to contact every single person that needs to be contacted. So if I have a contact sheet of everybody's information, then no matter what happens to the client, we have it covered on both ends. But there's definitely situations where having a family discussion of sorts could be beneficial. And I would say, here's a few examples of that. One, you have, you're a client or, a parent, and let's say you have a lot of wealth. It's not always advantageous when you die to just give all your wealth to your kids in a lump sum distribution. That's not always the best way to do it. There's other planning you might do to set things up to where when mom and dad die, the money is going to go into trusts for the kids, and they're going to have certain rules and procedures, and there's a benefit to doing that. But the kids might not see that benefit. So if they get kind of caught off guard or surprised when mom and dad die, they might feel like they got disadvantaged or mom or dad didn't trust them for some reason. But if you can bring them together and say, guys, here's why we're doing this, then they can see the value in it and understand why. So that is important, I think, when you have wealthier families, for them to understand in general the structure that mom and dad are putting in place, so they know what to expect when the time comes, and it's a positive thing, not a negative thing.
Good point.
I would say also, sometimes the client feels like one of their kids might be the best option to be in charge, so to speak. But they're still going to treat all the kids equally as far as what they inherit. But sometimes that might cause hard feelings with brother or sister. Why is so-and-so in charge? And why am I not part of this discussion? And they might feel like they were slighted or, again, not trusted, but that's not always the reason. And so if mom and dad can explain to the children that, hey, here's why we're doing this, then sometimes it helps them overcome those feelings, and they can kind of see why they're doing it. And that can kind of save some contention and hard feelings after the fact. Just a couple of examples, but I think there is a lot of value in at least thinking about doing that.
It sounds like the communication, and maybe for the kids to hear it directly from the parents, is maybe a more human way of getting that versus finding out later in the documents.
Sure. Yeah, it can definitely be a more natural way, and again, save some negative feelings and some fighting possibly too.
All right. Well, Taylor, is there any thing that we maybe missed today that you would want to share or urge people to think about?
Yeah, just kind of coming back again to those basics is, if you're thinking about doing estate planning, that's the right time to do it. And if you haven't thought about it, it's still the right time to do it. No matter who you are, what you have going on, you need some estate planning in place. It's a very flexible process, and the documents are very tailored to what you want and what you need. So don't let, the inevitable things kind of deter you from doing it. We're all going to die one day. We got to face it. It can be a positive thing or it can be a negative thing. Let's make it a positive thing and get it planning done ahead of time. If we get in an accident and we can't act on our own, that's a bad thing by itself. But if we have planning in place, it's going to be more manageable, and you'll be taken care of and have that peace of mind. So don't overthink it. It's for you, no matter what you have going on, and it's not as expensive. It's not as hard. It's not as stressful as you might think that it needs to be. But I just appreciate, Adam, the chance to talk with you about this and the invitation to come.
Yeah.
And always a pleasure to work with you.
Likewise.
And your clients. And, I always enjoy it.
Thank you. Well, I have noticed over the years that that people tend to put this off. So, and I do find that your team's approach, your office's approach has been soften that. And when people do go get the work done, they tend to feel really good about it. And they feel like there's that sense of accomplishment that they did something big and accomplished something.
And they do. And I'm glad you brought that up, because it is a big thing. I mean, that's, for a lot of people, that's a big step, and they should recognize that and kind of be proud for doing that. And, but yeah, I would agree with that. Certainly. We don't take it lightly, but it doesn't need also to be stressful. And, I never want a client to walk away feeling worse or feeling more confused. That's not a good thing. So that's what we try and emphasize, is just kind of solving some of those issues and those feelings.
Perfect. Taylor, what types of folks should contact you if they've done or not done estate planning?
Yeah, we can really work with anybody that kind of appreciates the process and wants to engage in it. If they have very modest affairs, we can help them. If they have more involved affairs, we can help them too. So we're not overly selective or we don't have certain requirements. As long as they appreciate good advice and are willing to go through the process, we're happy to work with them.
Great. And how would they get a hold of you?
Yeah, so they can get a hold of us, through an email or a phone call to the office. We have great staff who will schedule an appointment, and but they can email me directly. They can call the office and ask people like yourselves how to get a hold of us. So really, any method's fine.
Perfect. Well, thank you so much, Taylor, and collaborating and the relationship that we've had for quite some time. So thank you.
No, it's my pleasure, and thank you very much for the opportunity here.
Absolutely.